Hi, everybody. Welcome to the St. Mary's County Library presentation, Articles 4 through 7, the federal and state governments. This is part of a series about the creation of the U.S. Constitution, and tonight our guest speaker is Dr. Jim Gibb, and he'll be presenting on these articles with a focus on our system of shared power between the individual states and the federal government. My name is Allison. I work for the St. Mary's County Library System, and I'm going to be facilitating tonight's presentation. And then, Jim, would you be able to talk a little bit about yourself? I do see some new names here, so.
Okay, well, you are correct. My name is Jim Gibb. I'm an archaeologist, have been for 50 years now. I nominally in charge of the Smithsonian Environmental Archaeology Laboratory at the Smithsonian Environmental Research Center south of Annapolis, where we do all kinds of neat research, scientific work, and folks are welcome to come join us. We work mostly on Wednesdays. But we work every Wednesday. So anyway, hopefully that's enough. Before we get started, it's possible, I may from time to time ask Allison to read some text for me if I have trouble seeing it. So please just let her jump in and do that. Don't volunteer. Otherwise, we'll just get scrambled. Okay, so I'm going to share screen. So I usually start with a quote, but I figured I'd throw this up first before we get going. This is from the Articles of Confederation, which remember the Constitution replaces. And Article 4, Section 1, I thought is appropriate for tonight's talk, at least for the first part of it. Uh, the articles say the better to secure and perpetuate mutual friendship and intercourse among the people of the different states in this union, the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice excepted, shall be entitled to all privileges and immunities of free citizens in the several states, and the people of each state shall free ingress and regress to and from any other state, etc. It's kind of important because one of the real issues uh, that the Constitution doesn't really deal with very well, and which we're struggling with today, is what's a citizen? What constitutes a citizen? With the Articles of Confederation, remember, it was essentially a treaty organization among the 13 states. So there were no U.S. citizens because there was no U.S. There was simply 13 states meeting together in Congress. Uh, it says that basically this article applies to the free inhabitants of these states, and there are very few exclusions: paupers, vagabonds, and fugitives from justice. So, well, when they say free, they also eliminate slaves, of course. But beyond that, if you're here, you're an inhabitant, you're covered by this document, and you're entitled to all of the privileges and immunities of free citizens in the several states. Citizenship is essentially based on which state you're in. And even then, generally, there are no specific requirements for being a citizen of that state apart from actually living there. So, are free inhabitants also free citizens? And who are the people of each state? These are kinds of issues that we have struggled with and will continue for forever. Anyway, yeah, tonight's talk, I combined these four articles into one because they all more or less deal with the relationship between the federal government and the state governments. Articles 1 through 3 deal with the three branches of government. So it's within the government until the Constitution tells the government what it can and cannot do. And so this is the eighth in the series. The ninth, which will be next month, deals with the Bill of Rights and some interpretive theories that are applied to those Bill of Rights. Those of you who've been in on this before have seen this simple chart. And you can see Articles 1 through 3, that's the lion's share of the Constitution. Do it quickly, it's 83% of the words in the Constitution are used in those first three articles, and the lion's share in Article 1. So Article 4 through 7, they're actually fairly brief. and yet they also have a lot of importance. So we're going to start off with Article 4, and that is relationship between the state and the state governments and the national government. So in Section 1, they talk about the full faith and credit clause. This sounds like really, really boring. Full faith and credit, snore. But this is the statement in Section 1. We'll analyze it. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. That is, Congress has the right to pass laws that govern how we recognize official state documents. The issue here is that if something is legal, if there's a contract written, signed in one state, it has to be recognized in other states. Any proceeding, any legal proceeding in one state has to be recognized in the others. This become a problem numerous times over our history, but most recently, um, in the case of same-sex marriage. Uh, we have here a case, versus the Department of Public Health in Massachusetts. And the state Supreme Court there decided in November 2003 the Massachusetts Constitution requires the state to legally recognize same-sex marriage. Now, that was appealed over several months, but finally, the first same-sex marriage in Massachusetts was conducted in May of 2004. So you have a couple legally recognized as married in Massachusetts. Article 4 suggests that that marriage has to be recognized in every other state. As you might imagine, there are a lot of states that didn't like that. And then you probably all heard of Obergefell versus Kasich. That's Jim Obergefell uh, filing suit against Governor Kasich of Ohio and the state of Ohio. And his argument was Ohio discriminates against same-sex couples who have married lawfully out of state. And in this case, in Maryland, they were married in Maryland. And so the court, the U.S. District Court, federal court, issued a temporary restraining order. You often hear about these on the news as TROs. Ohio law has been clear. A marriage solemnized outside of Ohio is valid in Ohio if it is valid where solemnized, and noted that certain marriages between cousins or minors, while unlawful if performed in Ohio, are recognized by the state if lawful when solemnized in other jurisdictions. So was a major issue throughout the country in the first quarter of this century. It's founded on the fact that the Supreme Court found in 2013 the Defense of Marriage Act was unconstitutional. You may recall this from the Clinton years, the 1990s. And it violated the Fifth Amendment. It violated due process. And we'll get to this in a moment, but let me just sort of remind you here, the Constitution as originally written did not apply to the states. It only applied to the federal government. So because you had Fifth Amendment rights under the Constitution, that only mattered when you were dealing with the federal government. The states were not compelled by the Constitution to observe your Fifth Amendment rights. Uh, so uh, these same-sex marriages, according to the court, enjoyed same rights as traditional marriages guaranteed under the Due Process and Equal Protection Clause of the 14th Amendment. What that means is that the 14th Amendment has in it due process and equal protection clauses, the same we find in the Fifth Amendment. And the 14th Amendment applies to the states. So this 14th Amendment is so important. We hear so much about it today. It essentially is the first step in applying the Bill of Rights, which guarantees protections under federal law, to the states. The argument being, what good is it protecting somebody, let's say under the First Amendment, what's the good of protecting their right of free speech? Government will not arrest you for standing on a soapbox and yelling out certain things, but the state can. If the state can charge and prosecute a person for exercising their First Amendment rights under the Constitution, then the First Amendment right to free speech has absolutely no value. Uh, like some of you are old enough to remember Loving and Loving versus Virginia. This is a interracial couple, Mildred and Richard Loving, who left the state of Virginia to get married. If they went back into the state of Virginia, they would have been subjected to arrest because they violated Virginia's 1924 miscegenation law. And that, according to the Fourth Amendment, 14th Amendment, is unconstitutional because they're being denied due process and equal protection under the law. All right. Um, Privileges and immunities of citizens. This this section of Article 4 guarantees certain rights under the Constitution to citizens, but it doesn't actually tell us what a citizen is. The Constitution does not define a citizen. I don't think even the amendments define a citizen. Citizens are defined by statute. If you recall from our discussion of Article 1, one of the enumerated powers for Congress is they have the right to write laws that define citizenship and naturalization. Let's see. There we go. So the clause in there is the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. So that means that, whatever rights we enjoy in one state under federal law, we enjoy them in other states as well. Um, but you recall from Article 2 talking about the president and, vice president, their qualifications, senators, representatives, no person except a natural born citizen, so that is somebody who's born here somewhere in the United States, or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of president. So at the time, Alexander Hamilton, for instance, although not born in the United States, lived in the United States, was a citizen of the United States at the time the Constitution was ratified. So although foreign born, he would have been eligible for the office of president or vice president. But Section 2 implies that national citizenship derives from state citizenship. The reason being because prior to the ratification of the Constitution, there was no U.S. citizenship because there was no United States of America. There was a United States in Congress, that is, the states' representatives meeting in Congress, but there was no true unified country. So you had to be a citizen of a state instead. Um, and as you can see here, Articles 1 and 2 stipulate that you have to uh, be a citizen or a naturalized citizen, except for the president and vice president. They actually have to be native born. Okay. And yeah, Article 2, Section 8, subsection 4 is the one that's one of those enumerated powers that gives Congress the authority to establish a uniform rule of naturalization. So each state does not have its own naturalization process. It's only federal. There are two ways to U.S. citizenship under Article 4. Um, and one, again, is stipulated in Article 1, Section 8, where Congress has the right to establish laws. And so in those laws, Congress lays out what we might call a series of tests that one has to meet, not pass, it's not necessarily an exam, but certain criteria one must meet to become a naturalized U.S. citizen. The 14th Amendment was ratified in 1868, and its primary purpose, the primary intent, although it doesn't say this, was essentially to take all those people who were enslaved and since freed under the 13th Amendment and because they were born here, they're automatically U.S. citizens. And this is actually being contested right now in the Supreme Court. You know, are you a citizen just because you're born in the United States? 14th Amendment is quite clear. It says all persons born or naturalized in the United States and subject to the jurisdiction thereof. And what that means is, let's say a French woman working in a diplomat, a French diplomat in Washington. She's pregnant. She's about to give birth. She's transported to a local hospital, gives birth. Her child, although born in the United States, is not subject to the laws of the United States because the child, I suppose, has diplomatic immunity. So that child isn't automatically a citizen of the United States. But everybody else, there's there are no other qualifiers in there. Everybody else is a citizen who's born here. And if you look at laws and the Maryland Constitution, a citizen, I've asked this question when we first started this series. I've asked people, are you a citizen of Maryland? And if you think so, why do you think that? If you're a U.S. citizen and you're living in Maryland, you are a citizen of Maryland. If you pack your bags and move over to Virginia after you meet their resident requirements, you then become a citizen of Virginia. So that's how we deal with citizenship at the state level. A couple of important clauses are the extradition and fugitive slave clauses. These, in certain ways, echo other parts of the Constitution which do not prohibit slavery and prevent federal interference with the importation of slaves for 20 years after ratification, as 1808. So, extradition of criminals, a person charged in any state, we refer to as the demanding state, with treason, felony, or other crime, who shall flee from justice and be found in another state, that would be the asylum state, shall on demand of the executive authority of the state from which he fled, that is the governor or attorney general, be delivered up to be removed to the state having jurisdiction of the crime. Now, the thing is, let's say that I've committed a crime in Virginia. I beat it over the Potomac to Maryland. The governor of Virginia says, Wes, hand them over. What the government here in Maryland then needs to do is, assuming all the paperwork is right and correct, they need to arrest me. Once they've arrested me, then I can petition for a writ of habeas corpus. I can demand that the government of Maryland show cause for arresting me. So it's not simple. They don't just, ask and they run you over on an Uber or Lyft the following day. There is a process just like any other kind of arrest. Uh, the fugitive slave bit, which of course is obviously now obsolete because of the 13th Amendment. No person held to service or labor in one state. Isn't that a lengthy way of saying slave? I mean, they went out of their way in the Constitution to avoid using the word slave. Under the laws thereof, escaping into another shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. So this is in the Constitution. Somebody who's held in slavery escapes to another state. It doesn't matter what laws that state passes prohibiting slavery. Under Article 4, Section 2, subsection 3, they have to surrender on demand. They have to surrender that escaped slave. Uh, and again, this is earlier shows up in Article 1 about not interfering with the transportation of slaves. It was codified in statute law in 1793, and then more famously in 1850, the famous Fugitive Slave Act, which is considered one of the impetuses for the Civil War. There are a lot of very vocal anti-slavery groups in New England who resented the Fugitive Slave Act of 1850, and that just sort of added to the boil. Of course, that's all eliminated by the 13th Amendment. Okay, erecting new states. If you recall, when I talked about ratification of the Constitution, the talk just before Article 1, I noted that in the Constitution, we'll get to that part this evening, the Constitution was not ratified by state legislatures. That's important really to remember that. It has a lot of ramifications. The Constitution was ratified by conventions, sort of like Republican Democratic conventions today, but nonpartisan, by these conventions that were open to everybody, in which everybody who had a right to vote, which is, white dudes, but little or no property requirements. If you were, male, white, and reasonably sober, you can vote. And it's those conventions, state by state, that ratified the Constitution. So it was the people speaking, not elected officials. Again, we'll get to this in a moment. Article 7 requires that a minimum 9 states have to ratify in order for the Constitution to be implemented, for us to be a country. And that ninth state was New Hampshire in June of 1788. So less than a year, about 9 months after uh, uh, the Constitutional Convention signed off on the Constitution. New York was hotly contested, but they came along. North Carolina, not until the November of the following year, and Rhode Island, not until May of the year after that. So again, as I mentioned before, George Washington, when he was inaugurated as president in April, I have March 4th. It was delayed. It was in April. He was inaugurated, 1789. He was only the president of only 11 states. And I also mentioned when I talked about this, it was a very small margins, big by today's standard. If you've got 55% of people voting for something, that's considered a landslide. But that means you got 45% of the people who disagree, and 45% could be a lot of people. And so you can see the margins there of some of those states. Anyway, so we start off with 13 states. Uh, we added states. Uh, Kind of periodically over the course of mostly the 19th century. In the Constitution, it says you can form these new states, but you cannot form a state within an existing state. You can form a state from an existing state, but not within it. And so if you look at this map, I know it's a little hard to see, but let's start off with North Carolina. You have Tennessee next to it. Tennessee became a state in 1796. It was formed out of land that North Carolina claimed, but it's not within North Carolina. It's hiving off a big piece of it. Kentucky was erected out of Virginia. West Virginia was also erected out of Virginia, but not until the Civil War era. Um, Vermont was created out of New York. It was part of New York State. And Maine was erected out of Massachusetts, even though it's quite a ways apart, these two kind of land masses. Maine was considered part of Massachusetts until 1820. Um, and you can't, of course, none of these divisions could happen without approval of the legislatures of those states. I've got here a graph that just sort of shows you how this went. You see the first real big peak, 3 and then 8, those as first 11 states in 1787, 88. And then it drops way down, and you're down to pretty much one state every few years. A new state is added. There's a little blip in 1845 with 2 states. Um, and then a bigger one in the late 1880s, early 1890s. That was mostly the Dakotas, Montana, state of Washington, that neck of the country. Dropped down again and picked up again with Hawaii and Alaska after World War II. So, it's been sort of a steady growth throughout the 19th century after that initial burst. And think about that. How does that affect the politics of a nation as it grows? Think about your own community. If all of a sudden somebody plopped down, if you live in a, kind of typical suburban tract community, and all of a sudden, right smack in the middle of it, somebody bulldozed a bunch of houses and built a bunch of high rises. Well, a whole bunch of folks going to move into those apartments, whatever, and very likely they're going to be very different from the people who originally occupied that suburban community. So they're going to change the politics and the social life of that community. The same sort of happens when we add states. The politics change, and that's why there's been so much resistance about having having the District of Columbia essentially as our 51st state. It would change the balance of power considerably. Section 3, congressional authority over territories. This is something Americans really don't know very much about. You know, I mean, I grew up in an area where we had a lot of Puerto Ricans who had relocated to Long Island, met with a great deal of racial prejudice. I won't go into the names that were called, but Puerto Ricans who were born in Puerto Rico since 1917, this has been true. Puerto Ricans born in Puerto Rico are U.S. citizens, just like the rest of us, if they're born in Puerto Rico. Same thing for the U.S. Virgin Islands. Since 1927, anybody born in the U.S. Virgin Islands is considered a U.S. citizen. Samoa is a little bit different. Those who are born there are considered U.S. nationals, but not citizens. What that means exactly, I'm not sure. I've not researched it. I find it curious. Those born in Guam, U.S. citizens, the Northern Mariana Islands, which are considered a territory, they have their own commonwealth, so I'm not really uh, clear on what their relationship to the U.S. is. And since the 23rd Amendment to the Constitution, the District of Columbia, I mean, they've always, people in the District of Columbia have always been citizens of the United States, but they've not had the full franchise. And it's with the 23rd Amendment that the people of the District of Columbia can at least vote for the president. They have no senators. They have no representatives. If they were a state, they'd have as many as Wyoming, two senators, one representative. Montana, same thing. Um, so they're treated as if they had three electoral votes. They're given three electoral votes, even though they don't have the requisite senators and U.S. representatives. So they're kind of a special case. But their population is slightly larger than the smallest state population. Congress gets to decide what happens in those territories. They define by statute what fundamental rights are. They extend constitutional rights at their pleasure. They're not guaranteed. Uh, there are Puerto Rico, yeah, I guess Puerto Rico. U.S. Virgin Islands, I know, has a shadow representative. They have somebody who sits in Congress, as does the District of Columbia. They can work in committees, they can take committee votes, but they cannot vote on the floor of the House. So they don't, those communities don't actually have full representation in Congress. The amendment process, I know Janet has expressed some concerns about this to me. I thought we'd start off with the Articles of Confederation, ratified in 1781, replaced by the Constitution in the middle of 1788. Every state, I can't quite see what we got here. Every state shall abide by the determinations of the United States in Congress. This is a phrase they used before ratification of the Constitution. we weren't so much the United States of America as the United States in Congress, that is basically as a treaty organization assembled, on all questions by which questions which by this confederation are submitted to them. And the articles of this confederation shall be inviolably observed by every state, and the union shall be perpetual, that is, there's no way out. Nor shall any alteration at any time hereafter be made in any of them, unless such alteration be agreed to in a Congress of the United States, and be afterwards confirmed by the legislatures of every state. That means you can't change the document unless every state agrees to do so. As a result, amendments to the articles consistently failed, including those that would have allowed Congress to generate revenue to support the Continental Army, the Navy, and of course Congress itself. It had to be 100%. That was a defect that the framers understood only too well. Is probably the major reason why they came up with the Constitution. Don't read the stuff on the left. I just kind of summarized it. This is Article 5. It's a two-step process. Um, Two-thirds of both houses of Congress, that is, 66 senators minimum, and whatever two-thirds of 435 is, have to agree to amend the Constitution. Or it could be two-thirds of all states calling a convention for proposing an amendment. So federal legislators have the power and authority to at least begin the process of amending the Constitution. The states have that same power, although it seems, again, I have to research this a little more. It seems like the states would do so by calling conventions like those they called for initial ratification of the Constitution. Once that is done, once they get the requisite percentage of the states or of the houses of Congress, it has to be ratified by three-fourths of all legislatures. So three-quarters of all the states at the time have to ratify an amendment for it to become part of the Constitution, as if it were an original part of the Constitution. Alternatively, three-fourths of conventions called within each state. And there's also language in here prohibiting any amendments uh, prior to 1808 that would impede the importation of slaves. Anybody who says slavery, slavery had nothing to do with the founding of this country and Constitution and all that needs to read Article 5 and really the whole Constitution. So here's an example. Um, this is actually 3 years before ratification, but women protesting, demanding the vote. Um, and it finally made it through the Houses of Congress in 1919, and the following year, ratified by 36 out of 48 states. Remember, at this point, Alaska and Hawaii were not yet part of the United States. Uh, so 36 out of 48, which was exactly 75%. And so that's where we get the 20th Amendment. Uh, a similar graph to what I showed you before, only instead of states joining the Union, these are ratifications. These are amendments to the Constitution. Right up front, 1791, you see 10 of them, and that's our Bill of Rights. And uh, many people, including the Virginia, especially the Virginia contingent, demanded that we have a Bill of Rights. And if you haven't heard this before, sort of a sidebar, one of the issues behind the Bill of Rights and not adding a Bill of Rights was that people were afraid that if a right is not listed amongst those 10, then the assumption being that we do not have that right, even though there is verbiage in one of the amendments that says that's not really quite true. But that's often been an issue. I know our own what the abortion issue before the Supreme Court a couple of years ago, some of the justices said there's nothing in the Constitution that guarantees a right to abortion. And it's quite correct. There isn't. The
Um,
question is, yes.
oh, I was going to say, there was a comment in the chat from Janet. And didn't Maryland wait to pass the vote for women until the 1940s?
I don't remember when exactly. Well, I wasn't around, so it's not a question of remembering. But uh, Maryland, it was always late to the table. I mean, it's very rare when Maryland was up front. And in fact, the historian Robert Bruger referred to Maryland as sort of just sort of essentially sitting on that fence. We're always sort of neither left nor right. So I don't recall exactly when, but yeah, I'm sure we weren't first in line. But here you can see the number of amendments. We're basically looking at one, every now and then an amendment to the Constitution. On the really big years, there was, two in 1913, and that would be the income tax and the amendment that allowed us to vote for senators rather than our state legislatures voting for senators. And in 1933, um, one of those had to do with the terms of the president, vice president when they began. It's when we started having uh, our inauguration on January 20th instead of March 4th, and some other bits about that. And also, of course, the repeal of that amendment that's everybody's favorite. What is that? The 18th Amendment about prohibition. But otherwise, it's just like, one, occasionally one. A number of them in the 60s were civil rights related. Those after, particularly in the beyond the 70s, were really administrative stuff. Interesting, but you know, uh, not barn burners. So here I've got listed here the simple slide, these uh, peak years. First to 10th in 1791, federal income tax and senators in 13, and then terms of office and liquor control reverting to the states. That's important thing to point out too. The 21st Amendment, uh, the, it repealed an early amendment that basically put liquor control under the federal government. The 21st Amendment gave that control back to the states. And that means, a state could go dry. The state of Maryland could prohibit liquor, probably, possibly. I wish them luck on that one. But the control is with the state. And for those of you who travel around the country, I remember down in North Carolina in my youth working on the road doing archaeology. Some places, in some counties, you couldn't buy alcohol. In some counties, if you were drinking, you had to be sitting down. You couldn't be at the pinball machine, for instance. So it gets a little nutty. But I thought I'd throw this in here because the prohibition really grew out of a long-term social movement called the temperance movement. It started probably in the 1820s and continued until the 18th Amendment was ratified. I used to do a lot of work in New York State. A lot of social life revolved around whether or not you belonged to a temperance association. And if you didn't, you didn't have much of you didn't have much of a social life. So it was really important in rural America. But this slide is sort of cartoon shows the ascent and then descent. Having a drink to be social on the far left, having a little bit more, and some. I can't read these because they're too small. But you start getting drunk and crazy, and then you begin this decline down into poverty, social outcast, criminal activity until you finally kill yourself. But this is a really important movement in our country. A lot of Americans are wholly unaware of by and large. Uh, Article 6, debts and supremacy. Basically, the Constitution, Article 6, required that we honor all debts and contracts entered into under the Articles of Confederation. This was really important because this could have been a dodge. It could have been, okay, well, the government you contracted those debts with and those, contracts, well, it doesn't exist anymore. So poof, gone. We don't owe anything. Article 6 specifically says that we will honor those debts incurred under an earlier form of government. In dealing with the number of countries in Western Europe, that was really important because we owed them a lot of money. And to renege on those debts would have created uh, international problems and very possibly war. Uh, Section 2, the national laws and treaties are considered supreme. This is called the Supremacy Clause, supreme law of the land. And so that's not just what we think of normally as federal laws. It also includes things like treaties. If the U.S. Ha has a treaty with another country and that treaty is ratified by the Senate, it's part of federal law. Now, treaties rarely, if ever, govern individual behavior, but that treaty could then be used as a basis for Congress to write laws that force us as individuals to comply with the terms of the treaty. Um, I can't think of any offhand. This isn't something I've researched, but you could think about it. Constitution also binds judges of every state. Every judge, regardless of state law, observes the Constitution as the supreme law. Well, here's the wording here. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. So a state might enact its own law that is inconsistent with the Constitution. That law would be nullified under the Constitution. As an example, and this is before the Constitution, is the Articles of Confederation, but you all know we signed the Treaty of Paris um, with Great Britain, establishing peace between the newly erected United States in Congress assembled with this basically this treaty organization and with the Crown. And I like to use this picture because it was painted by Benjamin West, who was a noted portraitist. But it shows the American delegation, and they're listed there. We've got John Jay, for whom this and subsequent treaties were named for, uh, John Adams, Benjamin Franklin, Henry Lawrence, and William Temple Franklin, who was Ben Franklin's grandson and who was essentially their secretary. But you see the whole big whiteout area on the right? The British commissioners refused to sit for the portrait. They were pretty ticked. Anyway, that treaty governed behavior. And again, this is before the Constitution. And it stipulated in Article 4, creditors on either side shall meet with no lawful impediment to the recovery of the full value in sterling money of all bona fide debts heretofore contracted. So all those debts that were owed and not paid during the Revolutionary War, with the Treaty of Paris, those debts had to be paid, and the states were prohibited from passing any laws that would impede the payment. Now, the thing is, because we weren't a nation, we didn't have federal law, the Confederation Congress had no power to actually enforce this, causing a great deal of consternation over in Great Britain. And Article 5, the Congress of the Confederation will earnestly recommend to state legislatures to recognize the rightful owners of all confiscated lands and, quote, provide for the restitution of all estates, rights, and properties which have been confiscated belonging to British subjects, end quote. In Maryland, a lot of land, a whole bunch here, Maryland, and Charles County, I can think of, were confiscated and then sold by the state of Maryland to individuals. The Treaty of Paris required that the Confederation Congress earnestly recommend to state legislatures that they return those lands. Well, that wasn't going to happen. even though most of those lands were sold pretty soon before the signing of the Treaty of Paris. And so, yeah, we did not fulfill the requirements of the Articles of Confederation here. The framers, understanding this, being very familiar with it, made sure that in the new Constitution, these things will be done by force of law. And of course, it's up to Congress to pass the specific laws defining, how these payments will be made and what the punishments are for those who fail to comply. And section 3 of the article is the oath of affirmation. And here it is. This is different from the presidential oath. The presidential oath is in Article 2, and it's very specific. As I mentioned, when we talked about that uh, during one of President Obama's inaugurations, the Chief Justice misread the oath a little bit, and so the wording wasn't exact. So President Obama had afterwards in a private ceremony had to retake the oath. Um, but this one, it's in the Constitution, so it has to be adhered to. Um, actually, they don't provide an oath. The senators and representatives before mentioned and the members of the several state legislatures, that is, applies to state and federal, and all executive and judicial officers, basically everybody, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. So it doesn't actually specify an oath as Article 2 does for the president, but it says such an oath must be taken by federal and state legislators, executives, judges, probably all judicial officers. And it's that oath is that you will support and defend, or something to that effect, the Constitution of the United States. I remember having taken this oath a couple of times. Once when I was working for the State Museum in Arizona. And I thought a little weird then, but I didn't realize that, that's the way things were done. No religious test, that is, you cannot a candidate does not have to meet any specific criteria in terms of religion to be elected or hired um, to federal office. And that applies only to federal office. But through what we're going to talk about now, selective incorporation, it does apply to states. Selective incorporation is where the Supreme Court, in a case-by-case basis, trial by trial, finds that a state law violates the due process or equal protection clauses of the 14th Amendment, which forces states to comply with the Fifth Amendment. And so the Supreme Court can then tell the states, okay, this is not legal, it is not constitutional because of the 14th Amendment, which essentially applies the Fifth Amendment to the states. If that seems a little complicated, it really isn't that hard. It's just my delivery. So selective incorporation, here's the process. We have the supremacy clause. That is, federal government reigns supreme. It trumps all state law and, of course, all municipal law. The Bill of Rights, as I mentioned, applies only to federal laws and actions, not state law, as written and ratified in 1791. In 1868, the passage of the 14th Amendment extended the due process and equal protection clauses, excuse me, within the Bill of Rights to the states. So if a state violates, if somebody makes a case saying, look, this state law is violating my civil liberties guaranteed under the Bill of Rights and infringes on my right to due process, that law violates the due process clause, and therefore that right in the 14th Amendment is that in the Fifth Amendment is applied, or First Amendment is applied to the states. This is done on a case-by-case basis. This is true of pretty much everything that goes to the Supreme Court. Somebody has to bring a case and it has to finally work its way up to the Supreme Court. The court decides, and usually the court decides things very narrowly. At least the Roberts Court does. Tries to define it narrowly. So if you think it applies to a similar case, that case needs to be brought separately. So, Section 1, 14th Amendment, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So this applies just to citizens. It says so right there. But then it goes on to say, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So a state cannot bridge the privileges we have as citizens of the United States, but the states also cannot deprive any person, regardless of citizen status, of life, liberty, or property, or due process and equal protection under the law. So the 14th Amendment, again, which at least part of it is before the Supreme Court now, uh, is fairly specific. It's hard to wordsmith your way around what's there. And then finally, for this evening, ratifying the Constitution. I've already talked a little bit about this. And here's the wording. The ratification of the conventions, not the legislatures, of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. Done in convention by the unanimous consent of the states present. This is the unanimous consent of the states present at the Constitutional Convention. September 17th, 1787, and of the independence of the United States of America, the 12th, in witness whereof, etc. This is a common phrase in monarchical Europe. Often there's a date, a calendar date, and also the X year of so-and-so's reign. So 1770 would be 1770, the 10th year of the reign of King George III. And so briefly, that convention was adopted here in the Constitution. Okay, and so, where do we find out about the debates? I've talked about these before. These 2 books, they are compilations of largely newspaper, op-ed papers in newspapers, the Federalist papers, mostly, virtually all in New York. And here you've got these people who most of them were involved in the Constitutional Convention, uh, exploring what the various parts of the Constitution mean and how they should be interpreted. These aren't legal documents, these are op-ed pieces, but they've been referred to many times by Supreme Court justices, among many. And again, these are ratified by conventions. Here's the original configuration. The green are the original states, plus some additions like Vermont, Kentucky, and Tennessee, some adjoining territories, and then those in beige are all owned by other countries, at least up until 1800. Okay, so the implications of Article 7 it talks about how we ratify an amendment. Um, I'm sorry, it should be Article 5. Um, this is a comment I think is really important. The national government is not a creature of the states. And you'll hear this sometimes. The states should determine whether or not what the federal government does is right and constitutional. The states did not ratify the Constitution. The people of the states ratified the Constitution in convention. The people have sovereignty. That means the states do not have the power and authority to nullify federal law. A state cannot say, we're not going to follow this law because we think it's unconstitutional. Under the Constitution, they don't have that right. It can be amended, and the people do that, although essentially through their elected legislatures. Okay, I think that's it. All right, so that's about all I have to say this evening. I'm running a little bit long. The final piece in the series is going to be the Bill of Rights, the first 10 amendments, and how we interpret them and that should be fun. That would be kind of fun to do in a round table in person, but that's not going to happen. So there we go. I'll entertain questions. You don't have any questions, Allison?
Not a question, but a quick comment. Um, Oddly enough, though my parents grew up in New York City, they eloped to Alabama to get married. And in 1953, my father's 100% Hispanic and my mother is 100% Jewish. And my father gets very dark in the summertime. And my dad joked that there was a question about whether he should sign the colored book or not. And
Uh,
if he had to, then they wouldn't have been able to get married.
yeah,
And my question to them was, what the hell were you doing in Alabama in 1953?
for any reason whatsoever.
It's a
Um,
long story how they got there, but yeah.
but that's why I used same-sex marriage and interracial marriage as an example of this honoring of essentially contracts. In the United States, marriage a civil contract. I mean, there may be a religious aspect to it too if you get married in a church, a synagogue, or whatever, but it's ultimately in this country a secular arrangement. And so if it's honored in one state, constitutionally, it has to be honored everywhere else. And of course, a lot of states resented that before along racial lines, and then more recently because of same-sex marriage. Any other questions or comments, criticisms, complaints? In the meantime, like that'll be our last, and there'll be a respite for me and for you of this summer. I haven't really thought much about what I might do. I mean, I have some new archaeology talks that would get us through the fall, but if anybody's interested in a series like this, um, I'm game because I frankly learned a lot by pulling it together and realized just how little I knew.
I
All right.
also I also had a comment. You mentioned
Mhm.
back states cannot legally secede. I remember that a strange provision within like the Texan Constitution. They obviously can't secede, basically, but they can split into five states.
Well, yeah, certainly a state, as long as the legislature approves it, a state could divide into two or more states as long as no one uh, state or territory lies within another. I mean, one could pretty much wrap around, but you need a road going in to make sure that it's not, completely encompassed by a state. And as far as the illegality of it, it isn't so much that it's illegal, but with the Articles of Confederation and with the Constitution, there simply is no mechanism for leaving the Union. The Articles of Confederation said the Union's inviolable, that is, everybody has to stay in, but there's no hammer, there's no mechanism to force people. And in the end, all the states were basically disregarding the Articles of Confederation anyway. It was essentially a dead letter. But with the Constitution, there's no exit ramp. You're there because the people ratified the Constitution, not the states. This is the people's agreement to do this, not the states. So the states do not have the power and authority to secede from the Union.
One of the things I always find fascinating is how some states, and it's more than just California, can make laws affecting commerce that in essence become de facto national laws.
It's
Uh,
is a big it's a big state,
yeah,
like
emissions, the right
40
to re
million people.
yeah, the right to repair in Massachusetts, though, has become for like automobiles. Illinois with privacy, biometric privacy.
Well, you hear often people, legislators, congressmen saying, well, the states are, these laboratories of freedom, of democracy. Okay. California is a big state, and they decided, those of us who are old enough remember that state, Los Angeles was covered in smog. It was an awful place until we cleaned up the air. And so, California is a big stake in this.
Yeah. But when
And it
when it
makes
came
sense.
when it came to the railroads, they established the Interstate Commerce Commission. to be able to
Yeah.
deal with that so that you could have free access going through and not different regulations requiring railroads to
Yeah,
do it.
yeah, which doesn't exist anymore,
Well,
ICC. But
yeah, I know.
ICC also was formed in large part because the railroad companies were abusing people. They were fooling around with the rates at will. You were basically whatever they charged you had to pay. And so the federal government stepped in there because it's national. It crosses a state boundary.
Yeah.
Thank you for being here tonight, and we hope to see you next month.